afternoon, everyone, and thank you so much for joining us again today. We've got a crisp update today, just when you thought it was safe to go into the waters. Ask the Expert update. Today we'll be talking about the recent FAQ and some of the recent decisions made by our DC Circuit Courts of Appeal. So James will go into more detail, and we'll have some robust question and answer. And we also have today joining us our sponsor, HAPA, Ronelle Nolan. So we're very thankful for our sponsor, and she'll talk with you about Health Agents for America and how they help agents for America. So I'm going to go ahead and just do a brief introduction for those of you who don't know who we are. And for those of you that are students, bear with me. I'll be very quick on this. One moment, please. So today we're going to talk a little bit about certification. Those of you that are students know that this is a very amazing way to advance your career very quickly. Clients are searching for certified healthcare reform specialists in the area of knowledge on the ACA, and taking this certified healthcare reform specialist course gives you that foot in the door and the seat at the table with the CEOs and with the employers that are looking for the knowledgeable client to be able to answer questions. And the Healthcare Reform Center and Policy Institute brings you this certification. We've had thousands of certification students go through the program, and we're very excited about the program. We are developing more and more resources for our students, and one of these resources, I think the most invaluable, is of course these webcasts. They're consistent, they're timely, and they're brought to you with the experts by attorneys and professionals that are experts in the field of ACA, able to give you the information that you need about the ACA. For us and for this content, it is all about the instructors. Our instructors for the Certified Healthcare Reform Specialist Program are national legal experts. We also bring in the administration, the HHS, the IRS, the DOL. So it's a collaborative effort with the administration practiced in the ACA realm and in employee benefits, who's brought together the most important terms for our students and for our participants. We've got audit preparation and litigation, which is very important for employers and for brokers that are advising employers on how to prepare, what you need to do to get ready for it. So the content is important, content that we've brought together, and our compliance content is also really important for our brokers. Our reach. So the Healthcare Reform Center and Policy Institute falls under the Employer Healthcare and Benefits branch. We reach over 1 million human resource and insurance executives. We have over 500,000 to 500,000 members in our LinkedIn groups. Over 30 LinkedIn groups that we manage, and within those LinkedIn groups we manage a group of over 300,000 human resource executives. So we've got a very vast reach for our participants to network with, and we promote our students to these networks to let them know who are the professionals who have taken the next steps to show their due diligence, and employers are searching for specialists, and CEOs are asking their HR directors to become specialists. So we are collaboratively educating both employers and third-party administrators, as well as brokers, agents, and consultants for employee benefit plans. The importance of this is just to tell you about our social media reach. We did a recent study, and we found that over 93% of people that were polled indicated that they get most of their benefit information from social media. They are dealing with the social media. They are in their LinkedIn groups. They are in their Twitter groups, and they are getting the quick updates from these channels. And being that we've got such a huge reach in our LinkedIn presence, we find this staggering information to be important to our participants, to know that we've got a huge reach. We're promoting our students and helping get your name and your credentials out into the better part of the community of human resource agents and CEOs, or human resource executives and CEOs. So it's important that you know that our reach and our site and our guidance for you is there to get your name out there. We have a large branding campaign that we're running right now to our database of over 300,000 human resource professionals nationwide. And what we're telling them is work with our certified healthcare reform specialists. They've done their due diligence. They understand the ACA. And when things come up that are important for them to know, we bring that information immediately to them. So we're telling, our constituents to work with you. This year, our Congress will be held in Washington, D.C. It's September 20th through the 24th. We have over 200 speakers. We have 20 dynamic sessions. We'll be running the Certified Healthcare Reform Specialist live in person, or you can also take it online. For those of you that are specialists, you can earn your continuing education for your designation, as well as you can gain up to 14 hours of SBHR credit for your HR designation and 12 continuing education credits for your designation or for your state insurance license. The types of speakers that will be present, all Fortune 500s, from IBM to Lowe's. We've got LL Bean, Walgreens. It's a very, very wide cast net with speakers that are talking about everything from healthcare reform, the ACA, and how that affects their business, to wellness incentives and where do those fall within the ACA and legal compliance with that. So it's a very robust event, again, September 20 through 24, with large employers that will be speaking. We have a huge crowd of people, over 2,500 people attend. It is very unique in that we offer networking. We've got a unique networking software that allows you to participate prior to the event. 1 month prior, we open it up to our population. You can start networking with the people you want to meet prior to ever stepping foot in the door of the conference. And our goal is to connect you with the, with the people that you're interested in meeting, and through that networking software, we're able to do that. Very quickly, our CRIS students get CE. So this year, if you are already a certified healthcare reform specialist, we're offering the discounted rate of $500. The code to register is CRIS, C-H-R-S, GETS, G-E-T-S, CE, and that's where you'll enter at the payment screen. Of course, you can call me and I'll help you walk through the process. But again, it's a $500 discount. It's a very large value, and it's offered just to people that are already participants of the CRIS program so that they can earn their designation, their credits. Finally, we have a offer for those of you that wish to get certified. You can get certified in person for $995, and we'll complement the conference. So it's 14CERT is the code, and the conference is $899 right now, and it's $1,900 at the door. But you can pay $995, get your certification in person, and meet the experts in person, face-to-face. So without further ado, I want to introduce our first speaker, and James is a faculty member of the Healthcare Reform Center and Policy Institute. He is critical in helping us deliver this content, and we're very, very glad to have you, James. So James is a partner for RISA Practice Group and co-chair with Constanty Brooks and Smith, and we're so glad to have you join us for the next presentation. I'm sure it'll be a robust conversation, and Ronell Nolan will also be with us. So without further ado, I'll hand it right over to James.
Hey, thank you, and thank you all for joining us. This afternoon. I think we do have a nice webinar or webcast set for you today, and I would welcome your questions. We'll try to hold some of them till the end, but if we see some that come up on the screen throughout the presentation, we'll go ahead and try to answer some of those. It's been a very, last week and then this week, very trying times again within the Affordable Care Act. We titled this one just when you thought it was safe to get back in the ACA waters. We have these two court cases that are seemingly at the polar opposite ends of the spectrum, and we'll discuss how we got there and what it all means to you. So we'll talk first about the big picture, the Affordable Care Act structurally, how it's structured, what the issue is that's actually being litigated, what the various, the two circuits, D.C. And the Fourth Circuit held, and what it all means in terms of where do we go from here, including how employers should respond to these rulings at this time and what they should be doing, if anything. So here is a diagram, a simple diagram of the Affordable Care Act and its key components. We have the individual mandate that is supported by the state mandate, the employer mandate, and the insurance mandate. The state mandate, if you will, that's where the exchanges reside and the rules regarding the exchanges. So without the state mandate, without the exchanges running the way that they are supposed to run, we see that that ACA doesn't quite function the way it's supposed to. So we'll talk about that as we go into the court's rulings and what they mean with respect to this general diagram. Now here's the bureaucracy that supports all of that, the main provisions of the Affordable Care Act, and that bureaucracy is still being built. And once again, we have these two court cases that have thrown somewhat of a monkey wrench into this bureaucratic chart. The employer response is one of frustration, and I think it's warranted. I believe that the federal government itself understands that there is frustration out there with respect to the employer population as well as employees and then just individuals, because there is a lot of confusion. We are still seeing rules that need to be issued being issued. We're seeing revisions to old rules, and now we have court cases that, again, are really putting things into question as to how this Affordable Care Act is actually going to work in the long run. So let's look at the issue that's being litigated. What is being litigated? Well, the Affordable Care Act permits subsidies to be paid by the federal government to individuals who purchase health insurance through an exchange that is, and this is the quote from the statute, established by the state. Okay, so established by the state. Now, in 2012, there was some question back in 2010 when the statute was first passed, is what exactly does that mean, established by the state? And does it mean what some view it as meaning, and that is if you have an exchange that is facilitated by the federal government or is operated by some partnership between the federal government and the exchange and the state, that's not really an exchange that is established by the state. IRS stepped in 2012 and issued guidance basically saying, listen, we understand what the statute says. Congress couldn't have possibly meant that, and I'm, of course, paraphrasing. Congress couldn't have meant that. Clearly, individuals who purchase coverage through a federally facilitated exchange, or what these partnership exchanges where the federal government and the states work in partnership to operate an exchange, individuals who purchase coverage through those types of exchanges, they're subsidy eligible just as well as the individual who purchases coverage through a state exchange. So the central issue in these two cases was, did the IRS, overstep in issuing the guidance? Generally speaking, the IRS, like any government agency, is free to construe the terms of a statute in administering the statute, but it cannot actually legislate through guidance or through regulations. So what the IRS's role is with respect to the Affordable Care Act and these provisions is to look at those provisions and say, okay, this is what the statute says. Now here are some rules to put into operation the general rules under the statute. But it can't legislate new rules or can't legislate something that isn't in the statute or issue a rule that isn't expressly in the statute or, in this case, as some would argue, cannot override the express terms of the statute. The statute says established by the state. So a strict reading of that would say the IRS cannot by way of guidance, issue guidance that would say anything other than individuals can receive subsidies if they purchase coverage that is provided through an exchange that's established by the state. So that's really what's an issue. Now, having actually been involved in cases litigating issues where we have challenged the interpretation of a statute by an agency, I can tell you that it's a very difficult standard to meet, indeed, to try to get a piece of guidance overruled or thrown out by the courts on the grounds that the agency misinterpreted the statutory meaning or put in a rule that is in direct conflict with the statute. The courts generally give the agencies great level of discretion. Think of it as akin to the plan administrator for an ERISA plan, where the reviewing court looks at the plan administrator's interpretation of the terms, and unless it's a clearly erroneous interpretation of the terms, the deference is given to the plan administrator, so long as the plan document has the Firestone language, which gives the plan administrator that discretion to interpret the terms of the plan. Same concept here. It's the federal government, the agency, the administrative branch, if you will, of the government, reading, interpreting a statute, and then issuing guidance by way of informal guidance, by way of formal guidance that helps us to interpret the statute and to administer its provisions. So the first case that we'll discuss is the D.C. Circuit Panel case. It's a D.C. Circuit case. It was a panel of the case, a three-judge panel of the D.C. Circuit Court of Appeals that determined the absence of plain language in the statute authorizing subsidies to individuals covered on federal exchanges meant no subsidies were available. So what the D.C., this three-judge panel, and the makeup of the panel, by the way, was two Republican-appointed judges and one democratically appointed judge. Now, typically, politics has no place in the courts. A judge is supposed to, sit, and I'm not saying that politics does play a role in the judge's own decisions. What it does do, though, is where politics comes into play is if you have a Republican-appointed judge, one would believe that that judge is more likely than not going to be conservative-minded on the way that he or she approaches the law or a case. And on the flip side of that, if you have a democratically appointed judge, one would think that that individual judge would tend to be a little more liberal-minded. Now, what that means in terms of cases like this is statutory interpretation. Not to bore you too much with the common law and statutory interpretation law 101, but I think it's something to discuss to lay the foundation for why the different courts came to the conclusions they did. A more conservative-minded judge is going to look at statutory construction as a strict constructionist, meaning he or she is going to look at the statute and give the plain meaning of the words, plain meaning of the law with respect to the words that are in that statute. So if we go back to the slide before, that bolded language there, established by the state. The statute clearly says that subsidy-eligible individuals are only those who purchase coverage through an exchange that is established by the state. So the absence of terminology such as established by the state and or the federal government, established by the state and or facilitated by the federal government, that lack of any language covering the federally facilitated exchanges is what the two judges on the district court, D.C. Circuit Court Appeals, panel, that's where they hung their hat. And they basically said, hey, the strict interpretation of the language, it's clear. I'm looking at the four corners of the statute. I'm not looking beyond that, and I don't even need to look beyond this provision of the statute because the language is clear and unambiguous. So in finding that, the panel held that the IRS overstepped in its guidance permitting individuals to receive subsidies through the federal exchanges. Now let's go to the other end of the spectrum on statutory interpretation and look at King v. Burwell. So the panel of the Fourth Circuit Court of Appeals, the same day, about 2-3 hours after the D.C. Panel handed down its decision, held that the context of the statute permitted subsidies in federal exchanges while recognizing that there is no ACA language explicitly authorizing the subsidies. Okay? So this is one where the judges on this panel looked at the statute itself and really said that, you know, in looking at the statute as a whole, not just keying in on the provision, those 3 words established by, or I guess 4 words established by the state, but looking beyond that and looking at the context of the statute and what is meant. Remember, going back to our actually, let me go to it, to one of our first slides here. This is what the Fourth Circuit panel was looking at when they were making their judgment in the context of the statute. And they were looking at it and saying, you know, well, the individual mandate is tied to the state mandate, which is tied to the employer mandate. They all work in unison. You need the employer mandate to function properly in order for the individual mandate to function properly. And actually, that's a position that was taken in the litigation. I briefed it for the American Benefits Council in the first go-around where the Supreme Court was ruling on the individual mandate, and it was a severability issue. And it is clear that the employer mandate is meant to support the individual mandate, so without the individual mandate, there's no employer mandate, and vice versa. So when you look at that in the context of the statute and the way the statute works, it would seem an odd result indeed for the Congress to write an act that says, you know, only individuals who purchase coverage through a state exchange will receive the subsidy, a subsidy that is necessary for that individual to meet their mandate because it makes the coverage affordable, as well as a subsidy that is necessary to trigger the penalty under the employer mandate. And we'll talk about that in a few minutes and how that all works. So there were two different ways of looking at the statute. And the question now is, well, what does this all mean? You know, I don't want to go too far into exactly why the, panels held what they held because it gets pretty deep. Other than to say the one panel looked at it in a strict statutory constructionist, the others looked at it more in terms of function and looked at the statute as a whole and what was trying to be accomplished. There was some nice verbiage about, you know, hiding an elephant in a keyhole in the Fourth Circuit case, and that's, you know, nice and flowery language. But for our purposes, all we need to know is the Fourth Circuit ruled that the IRS did not overstep its bounds when it issued the 2012 guidance, stating that individuals who purchase coverage through federally facilitated exchanges will likewise be eligible for subsidies, while a panel of the D.C. Circuit Court held just the opposite. Now, procedurally, there are a few ways that this can go. The cases will most likely be appealed, if they haven't already, to the full circuit for review. So, again, in the D.C. Circuit, we had a 3-judge panel. The entire D.C. Circuit is made up of 11 judges, 7 of whom, I believe it's 7 who were democratically appointed and 4 who were Republican appointees. So there is a thought that this will be appealed to the full circuit. Now, just because it's appealed to the full circuit doesn't mean that the full circuit will necessarily hear it, agree to hear it. There are different circuits have different criteria for review, you would think that this one would meet most of the criteria, and that it's a very significant issue that, requires additional review. That being said, again, having litigated, and most of mine were in the Sixth Circuit, where there was a panel decision, it's often difficult to get the full circuit to hear. Even in, a couple cases I had were very significant cases from an ERISA point of view. Even in those cases, the circuit just wasn't interested, which means it goes either to the remand to the district court for an order implementing the panel's ruling, in which case, or it can be appealed directly to the Supreme Court for review. So I would imagine that if the full circuit declines review, the litigants will likely appeal it to the Supreme Court. Now, if it's appealed to the Supreme Court, the likely course would be for the Supreme Court. I would imagine the court accepting this one, and I would imagine that it would likely hear the case sometime in 2015, so June of 2015. Now, that being said, there are situations where there can be an emergency appeal to the Supreme Court. Again, it's difficult enough to get to the Supreme Court, let alone to get the Supreme Court to act, outside of their regular course, which would take us into 2015. The argument here, obviously, would be there is a split in jurisdiction. This case is essential to the Affordable Care Act's viability moving forward. In the absence of some ruling that gives us a rule one way or the other, there's going to be confusion, and the employer mandate is applicable come 2015, at least for the larger employers. So we'll see what happens there. Now, one of the questions that I've received in the past few days is, if the D.C. Circuit decision is ultimately adopted as the law of the land, what would happen? What would happen if individuals were only able to receive a subsidy through state exchanges? Individuals in states with federally facilitated or partnership exchanges would not be subsidy eligible. So you'd have a host of individuals who the Affordable Care Act was trying to bring into off the sidelines, if you will, and into the insurance market, will be left on the sidelines. Employees who reside in those states could not trigger a penalty under the employer mandate. We know that the employer mandate is triggered when one or more full-time employees receive coverage through an exchange that is subsidized. So if there's no subsidy, it's that receipt of the subsidy that triggers the penalty on the employer under the employer mandate. So if there are no subsidies, there's no penalty. That would mean that employers with employees in the states, employers with employees in states that do not have state exchanges, so they have the federally facilitated or the partnership exchange, those employers may view the mandate a little differently and might not feel that they need to comply because the mandate is now a toothless dog. There's no teeth behind it, because if there's no real penalty, then there's no real reason to go ahead and comply with the employer mandate. And we'll talk about that a little more in a couple minutes. But here's the map, and this is a key map. And actually, I can remember years ago in 2010, we were looking at this map, 2011, looking at, it wasn't this particular map, but it was a similar type map. And a lot of what's happening today, by the way, was predicted back in 2010. This is not a new issue. This is something that shouldn't have caught anybody necessarily off guard. I know I personally have been speaking about it for a couple of years now in presentations about, and saw that the litigation was brewing. The question was the timing, when it would actually happen, and what how the issue would come to light. Would it be through litigation of this nature or some other form? But in any event, we have the cases now. So all of those states that are in yellow, these are the states that have defaulted to the federally facilitated exchange. The light blue states are those that have partnership exchanges. So if the D.C. Circuit opinion, the panel decision, ultimately becomes the law of the land, any individual who lives in the yellow or light blue states would not be eligible for a subsidy. So a lot of people would be left with unsubsidized coverage through the exchanges, meaning it would likely be unaffordable to them, meaning they would likely face a penalty under the individual mandate. Now, those who are in the blue states would still be, the dark blue states would still be subsidy eligible. So the question is, what does this mean politically? I think what it means, and this is what we mentioned on our webcast last week, is that the politics of the Affordable Care Act has now moved to the state level. States are already looking for ways to be considered as providing exchanges that are established by the state. They're challenging the notion of what it's meant to be established. Let's do some for examples. For example, if I have a federally facilitated exchange, does that necessarily mean that my exchange was not established by the state? It's run by the federal government, but could I not, as the state, have nonetheless established that? I, as the state, had the option, right? I made a choice, and my choice was not to run my own exchange, but to have the federal government run an exchange for me. Have I not established an exchange? Think of it now in the context of an employer and their benefit plan. Most employers don't actually administer their health plans. They sponsor the plan, they establish the plan, but they have a third-party administrator actually run it. So would you say, for that purpose, if I am a plan that, let's say I'm a fully insured plan, so I don't administer it at all as the employer, I just purchase the insurance, is that plan no longer established by the employer? From an ERISA perspective, it absolutely is. It's established by the employer, and it's therefore subject to ERISA. So, too, is the argument here that if I'm a state and I've made the choice to have the federal government run my exchange or the exchange in my state, have I not adopted or established an exchange? I just opted to have the federal government run it for me. So there's still a lot of play to be had here. But we're also seeing state legislatures looking at it and saying perhaps they need to take more affirmative action than just making an argument like that. They need to take an affirmative action to really establish. And I believe it's by November of this year each state has the ability to re-up and make a new decision as to where they're going to be. So if it's a federally facilitated state right now, the state can step in and say, we're going to take it over. So there's a lot. The politics has moved from the federal government to the state government. Now, that being said, what does that mean for the argument that the district panel was correct? If I'm conservative-minded and I'm looking at the statute as it's worded, I'm going to say, this is exactly what Congress had in mind. Rather than hand down an unfunded mandate on the states and require them to take action, what the federal government said in this statute, in the Affordable Care Act, is if you, the state, take on the burden of administering your own exchange, we're going to offer you the carrot of subsidies to your residents, to your state residents. So we, as the federal government, will subsidize the coverage that's provided through that exchange. However, if you put the burden of running the exchange on the federal government, you're not going to get any money from us. Your citizens are not going to receive any money from us. That's ultimately what the DC, what the result would be under the DC panel's decision. And from a conservative point of view, that's not all that earth-shattering, and that's probably how it ought to be, is it should be a state decision, and the states decide whether they want the federal money or not. But we'll see. So I just say that not because I'm not saying that's my personal opinion on it. I'm just trying to give you the context of, when people ask, okay, we know it's going to go to the Supreme Court, what's going to happen there? The answer is nobody knows. It's just like everybody thought for sure the individual mandate was going to be struck down by the Supreme Court. The Supreme Court's opinion upholding the individual mandate used the term tax a number of times and held that it was within the Congress's taxing authority. That's what saved the individual mandate. How many times is the word tax used in the Affordable Care Act? I don't think it's used at all, particularly in reference to the individual mandate. So there was some gymnastics done there that, okay, it can make some sense. But nobody, if anybody says they know what the Supreme Court's going to rule on this, I don't think that, I wouldn't take that bet. I wouldn't believe them. I think it could go either way. I could see where you could have a five-justice majority, where you have the more conservative-minded justices walking through the statute just as the D.C. panel did, and then also having the comfort of knowing that, ruling in this way does not necessarily decimate the Affordable Care Act. It just puts the politics of the Affordable Care Act at the state level, and each state has their, the ability to sponsor its own exchange and get the federal subsidies for its citizens. So how should employers respond? Right now, I think you need to continue with implementation as planned. The D.C. Circuit ruling, number one, it's a panel decision. So there's going to be an appeal to the full circuit, and whether that's accepted or not, we'll find out. And then it will eventually go to the Supreme Court. That being said, as a matter of law right now, the panel decision only applies to employers who sit in D.C. So assuming that nothing happened with it and it stood as good law, that would only impact employers in the D.C. Circuit. Fourth Circuit employers and individuals who reside in the Fourth Circuit, they're going to be under a different rule where it's clear that individuals would be able to receive the subsidies through the exchanges. The other thing to note is that if the D.C. Circuit panel's decision were to become the law of the land, remember, it doesn't mean that employers are completely off the hook. If I'm an employer who has employees in states that do provide a state exchange, then those employees are still going to be able to trigger the penalty under the employer mandate with respect to me as their employer. So, for example, if I have employers, employees, go back to our map. Let's say I have employees in California and Arizona. If the D.C. panel's decision were to become law of the land, while those employees in Arizona, as it currently stands, would not be able to trigger a penalty vis-a-vis me, those individuals in California, my employees in California, could trigger a penalty. And under that penalty, if it's, let's say, failure to provide coverage at all, make an offer of coverage to at least in 2016, 95% of my full-time employees, then the head count in Arizona will count towards that penalty determination. Even though the individual may not be able to trigger it, they will still be included in the head count. So it's something where these cases are very exciting right now, and that they're present from a legal, from an attorney's point of view. They're very exciting in that there's some diametrically opposed ways of reading a statute that have been invoked by both panels. But from a practical point of view, it really means at this point for employers to keep the status quo. As I said, if it reaches the Supreme Court, I would not be surprised if it doesn't do so until 2015, perhaps even after that. If employees reside outside of D.C., then the ruling doesn't apply with respect to employers that are domiciled outside of D.C. Would I go and start moving my employees into states that have the federally facilitated exchange in place? No, not at all. I think it's status quo, continue with implementation. If in fact the Supreme Court were to hear this case sometime in 2015, or we get a ruling sometime in 2015 or 2016, I cannot imagine that case, that ruling would have retroactive effect, which that means if you're outside of the D.C. circuit, you're going to be subject to penalty. And if you start to hedge your bets now and say, well, I'm going to sit back and not really implement this year. I know I'm subject to it in 2015. I'm a large employer. I'm going to sit back and see how this all works its way out in the courts. You're going to be subject to penalty in 2015, and I don't see a scenario where even if the Supreme Court were to uphold and agree with the D.C. Circuit panel, where they would go back and say, and therefore all of those employers who were penalized in 2015 for failure to provide coverage to employees who are in federally facilitated exchanges, they don't face that penalty anymore, because I don't think that the Supreme Court's ruling would also, on the other hand, say, and employees or individuals who receive those subsidies have to pay them back because they shouldn't have received them. So it's another issue that we looked at heavily during the first go-around at the Supreme Court on the healthcare reform, and that was, retroactive effect. It's something that we're going through right now with the same-sex spouses, and the ruling of the Supreme Court in that arena is, do you give retroactive effect to that ruling? And generally speaking, the court retroactive effect is not given unless it's something that can pretty easily be applied retroactively. But to try to undo years of transactions and, in this case, if we're a year out, a year of penalty and subsidies, that I just don't necessarily see that. So I think continue with implementation as planned. I don't think that at this point you can say one way or the other which panel had it right, because there are different ways of interpreting it, and we will know which panel has it right once it reaches the Supreme Court. With that, we can open it up to some questions. While we're waiting for questions, one thing that I would note is Jenny had introduced the Healthcare Reform Congress in September, which happens to be out here in D.C. this year, so it's an easy trip for me. But I would encourage you, if you're not already planning on attending, to attend, because there are a lot of great speakers and you'll get real down to earth. What does this truly mean to me? And see what other employers and providers are doing.
Okay, James, you can hear me now?
Yep.
I just want to make sure you can hear me now. Great. I'm going to ask one question, and then I will open up the floor to Ronell to talk about some of the things you've talked about, as well as to tell us about HAFA. And we'll continue to answer the questions that are rolling in, and I'm trying to organize them as they roll in. So be patient, and I'll get those answered, and I'll field those questions. So
sure.
So the first question I have here is, Brad, if Scouts were to uphold that the IRS oversteps its powers, how would you see the rollout for the changes happening? Would 2015 subsidies continue until the end of the year? And if not, would a class action suit result if enrollees that were misinformed?
Yeah, that's a really good question, and it touches on what I was talking about a couple minutes ago. And if the Supreme Court were to rule in favor of the D.C. panel, I think it would be on a going forward basis. Now, whether it would mean that subsidies cease right at that time, I could see where you could take the position that, yes, they should be cut off right at that time, because the majority of individuals who are subsidy eligible ought to have already received their subsidy through the exchange, because they would have already gone through open enrollment for that year. So the only individuals who would be subsidy eligible after that ruling, assuming it's sometime next, summer or fall, are those who have special enrollment events. On the other hand, I could see it being, effective 2016. That said, what's going to be really interesting is how the states react. So let me step back and say one additional thing is, if I'm an employer in a state that has federally facilitated or partnership exchange, what I really should be looking at now in terms of including continuing on my implementation path is really follow your state and see what your state is doing. Because if the Supreme Court upholds the D.C. panel, but your state over the coming months and year adopt and establish a state-based exchange, then the ruling really doesn't mean anything to you at that point.
Thank you, James. I appreciate it. I'd like to introduce Renelle Nolan. She is a partner of ours and a sponsor with Health Agents for America. And Renelle, I'd like to hand it over to you and let you talk about some of the things James has talked about and give us some information about HAPA as well. And thank you again for your sponsorship.
Thanks, Jenny, and thanks, Jim. Health Agents for America absolutely is above average proud. We're a independent agent association, and we're the ones that are trying to survive. And these things that James explained to us are so very important to our association. I would like to say that we will be at the Employer Health Congress in Washington, D.C., and on the fourth day, on the 24th, we will be on Capitol Hill. We're going to take a publication that introduces our senators and representatives to agents, and then have some stories to tell them how we helped in this most recent open enrollment. And then lastly, we have an agent summit coming up where people can get their certification for CHRF on October 9th and on the October 8th, excuse me. And on the 9th and 10th, we're going to have an agent summit. It's not Louisiana state specific. Jim will be one of the presenters along with some other wonderful presenters from across the nation. But we're going to sit down and learn how we can survive. I had a couple of questions for Jim. You mentioned that states could be considering changing from a federally funded marketplace to a state federally funded marketplace. Have you heard of anyone specifically having those conversations, and if so, if you know what state?
That's a good question. I'm in making that statement, I'm going off of the reports that I'm reading in the media. I do not personally know of any state that is having, that conversation, but I am told through media sources that those are going on, and it doesn't surprise me.
And Jenny, can I ask one more question?
Absolutely.
Thank you. How do you see this affecting agents and brokers? As you know, we've enrolled so many millions across the nation, including subsidies. So if this should be ruled by the Supreme Court that subsidies are not eligible in federally funded marketplaces, and all these sales really go away. Do you have any insight on how that would affect the agent and broker community?
Yeah, that's a very good question. I think in terms of, again, just touching on the retroactive impact, I don't think that we're going to see retroactive where the federal government, the IRS, goes back to individuals and says we want those subsidies back. And even if that occurred, I don't see how that would find its way back to liability for the broker. If, on the other hand, we are in a system on a going forward basis where there are no subsidies, in some respects, perhaps that enhances the need for a broker under this system, because now you really need someone who's going to find you good, affordable health care absent a subsidy. So that's going to take you potentially outside of the public exchange and into other markets. So I think you would need a broker more than ever. Now, one of the things that we're going to speak about in October at the HAFA event is exactly how brokers should be preparing themselves today and for tomorrow, and how to best protect themselves from liability. An individual or an employer who is a client coming back and saying, well, you told me that this was the law and this is how it was going to work, and now it's not quite that way.
Thank you, Jim. I do have another question here, and thank you so much, Renelle, for joining us and talking to us about the association. And if you have more questions, Renelle, pop in because we're happy to answer them. I'm going to ask one more, and of course, pop in if you have one, Renelle. This one's from Daniel. It says individuals whom were given subsidies for this year and may be given in 2015, do you think there will be a chance that they'll be asked to repay the IRS? I think she kind of asked that, but again, sorry.
Yeah, that's okay. Yeah, I don't see it.
Okay. In the interest of time, because there's a lot of questions and I want to get them all answered, but we do want to stop promptly at 2 with everybody's schedules. What I'd like to do now is just offer thanks to you, Jim, for joining us once again, and offer thanks to Renelle, and let everybody once again know that if there is any information that you need, if you are a certified healthcare reform specialist, you have access to the Ask the Experts, and so your questions can be answered, almost immediately. It's within 24 hours, and we've got experts that are waiting to give you that answer and help you on your journey for delivering information. So again, thank you, James. Thank you, Renelle. Thank you, HAFA, for sponsoring this webcast for us today, and thanks to all for participating. We appreciate you all, and we will have another one coming up soon. So join us at the conference, September 20 through 24, or of course you can join us in October, on October 9th and 10th in Louisiana. The conference will be in Washington, D.C., September 20 through 24. Thanks again for joining us, everyone, and have a great day.
Thank you.